Hey, Kathy, it's Adina. I'm going to chime in real quick. I don't think anyone can hear you unless it's just me.
Well, let's start that again. Good afternoon. This is Kathy Graham at Pay Entry. You're welcome to our weekly webinar. As I mentioned, I'm going to be conducting today the webinar. I'm head of the HR Services division, and I do have on the call today Adina Glencher. She is our senior HR advisor. She just listens to tell me that nobody can hear what I'm saying, and that's always good to have somebody on when you're doing a webinar like this. So, um, we're going to talk about today the Bermuda Triangle of leaves. And first of all, to let you know what a Bermuda Triangle is, it's an area in the Atlantic Ocean where an unusually high number of ships and planes have disappeared without a trace. Whether it's a magnetic field or aliens are abducting things in that triangle, who knows? But it's an odd area with a lot of weird things that happen, just like they do when you're trying to put together ADA, FMLA, and workers' comp leaves. The interplay or the interaction between these three laws is very complicated and creates certain problems when you're trying to administer these plans. It is often referred to as the Bermuda Triangle of employment law. One of the things that's made this even worse, we're not just now dealing with ADA, FMLA, and workers' comp leaves. We're also dealing with state laws. States have also established their own paid family leaves with a variety of rules. And if your state or states are on this list, then you have more of a headache than most people. So, if you going through this, we're only going to talk about the federal leaves, the ADA, FMLA, and workers' comp. But you may have another one to throw into this mix, or two, depending on which states your company operates in. Here's our agenda for today. We're going to look at the importance of recognizing and analyzing that interplay between the three leaves. We're also going to look at the important areas that connect or overlap, the purpose of the three laws, who cares what you do in each one of these leaves, so who enforces the rules. We're going to give you an example of an absence involving all three leaves, and then we'll go over a summary at the end. So let's start off by looking at the statement that the majority of absences related to illness of employees and family members um, come into play when you're looking at these three laws. So one, two, or all three laws may be involved. So if someone comes in and files an FMLA leave um, or an ADA leave, you have to look at these other laws also. Violations, where you miss compliance with one or the other, may result in penalties that include lost wages and back pay, reinstatement, retroactive benefits, and sometimes compensatory damages and even punitive damages. It's important that companies recognize the moral and ethical responsibilities to make sure that employees receive the protection and the benefits that are allowed under these laws or demanded under these laws. So there are important areas of interplay or duplicate coverage between the three laws. One is employer coverage, employee eligibility, the length of the leave, what kind of medical documentation you need. We'll talk a little bit about restricted or light duty, and fitness to return to work. Certification, is that required in all of the leaves? And the benefits while on leave, and finally reinstatement. So all of these have different rules for different laws. Okay, so first of all, let's look at the Americans with Disabilities Act. It prohibits discrimination against qualified individuals with a disability or someone who has a record of disability or they're being regarded as having a disability. In that respect, you could look at somebody that, is associated, has a family member that has a certain disability, and so that pairs them with that dependent. Also, things like drug abuse and alcoholism in the past may give someone the perception that it's still a disability. The Family and Medical Leave Act sets minimum leave standards for birth and care of a newborn, placement of the child for adoption and foster care, care for immediate family member with a serious health condition, and then care for an injured service member. And then workers' compensation actually is not a federal law. It is state specific depending on the benefits that you have to provide. It does provide for payment of compensation and rehabilitation for workplace injuries. It also minimizes employer liability and protects against retaliation and job loss. Those are the basic purposes of those three laws. The enforcement authorities for the Americans with Disabilities Act is the U.S. Equal Employment Opportunity Commission, so the EEOC. The FMLA is actually governed by the United States Department of Labor, and workers' compensation laws are governed by state workers' comp commissions. So they all are governed by different players, which would result in, if there is a violation and you're using all three of these, a violation could result in penalties from each agency. So let's look at the overlap and the areas of interplay. For employer coverage, this is who has to comply. Under ADA, employers with 15 or more employees for 20 weeks during the current or preceding calendar year are obligated to follow the Americans with Disabilities rules. Under FMLA, you have to have 50 or more employees within a 75-mile radius for at least 20 weeks during the current or preceding calendar year. So this is looking back at how many you had or how many you have right now. And then workers' comp applies to most, even very small employers. If you have one employee, you are governed by workers' compensation. So let's look at who's eligible, which employees are eligible for coverage or protection by these groups. Under ADA, any employee or applicant who's disabled and that is as defined by the ADA. It's not just disability that someone quotes as something that they have. It has to be defined by the ADA to qualify. So if they're disabled and they're qualified for the position and can perform the essential functions of the job with or without accommodation, that is the protection for any employee or applicant. Under FMLA, any employee who's worked at least 12 months and 1,250 hours in the preceding 12 months before the start of the leave, they also must report to a work site of 50 or more employees in that 75-mile radius. So first of all, the employer has to be required to participate in this. And then workers' comp, it's any an employee who incurs a work-related injury or illness. How long can the leaves be under each one of these? Well, under the ADA, there's no specific limit for the amount of leave that an employer would need to provide as a reasonable accommodation, as long as it does not create an undue hardship for the employer. And it is job specific. So if it's a key employee, maybe the ADA would look at the fact that that person can't be out for a long period of time because of the gap in knowledge, or and for any other type of position that would be highly technical. It depends. It depends on all of the circumstances involved. Under FMLA, an employee can take 12 weeks in a 12-month period as defined by the employer. So you can use a rolling calendar year, you can use a look back period of time. There are I think three different ways to look at it. The person also has 26 weeks, not in addition to, but a total of 26 weeks to care for an injured service member. And then workers' compensation, there is no specific limit for the length of the leave. Medical documentation required under the ADA is only information that regards the employee's disability, that are job related, determine their ability to perform the job, and whether or not an accommodation is needed. And this is something that you would get from the employee and their physician if they come forward, or if you're aware of a disability, and you're trying to accommodate it. During that process, you would need to go through and determine if the disability would prohibit them from doing the job, basically the essential functions of the job, and how you can accommodate them. Under the FMLA, medical certification of the need for leave does not have to, cannot exceed the requirements of the Department of Labor's medical certification form. It's very thorough. I don't think you would want any more than that. They do have a form that you use to procure that information from a physician. And workers' comp. Medical information pertaining to the employee's on-the-job injury or illness would be required by the treating physician for you to understand the issue. Under each three of the leaves, restricted or light duty, under ADA, it would is required if it's a reasonable accommodation that does not place undue hardship on the employer. So if someone cannot return to work at the end of a leave, but you can bring them back to work in a different position or for a different number of hours per day, that would be considered a reasonable accommodation under ADA. Under FMLA, you cannot require this. You cannot require them to come back to work on restricted or light duty. And under workers' comp, this should be offered always if it's available to eliminate time away from work, because the longer a person stays out, the less chance there is of them actually returning to work. And that impacts all your claims and your costs going forward. So it's definitely something you should always be working toward in a workers' compensation claim. More areas that they interact is the fitness to return to work certification. Can you require that? Well, under ADA, it's permitted as long as an exam exam or inquiry is necessary to show that they can perform the essential functions of the job. So you would have to have a doctor's input on whether or not the person could perform the essential functions of the job. If it's a light duty position, then you would be looking at different restrictions. FMLA, under FMLA, can be required only under a policy or practice that's applied to similar types of leave. So if you have someone that goes out to have a baby, or you have someone who breaks their arm or their leg, if you require them to have a fitness to return to work certification, then under FMLA, any of the other types of leaves under there, everybody has to be required to do the same things. It has to be consistent. One of the words that we use a lot in human resources is consistency. And under workers' comp, it is typically required for the insurance company to be able to end a claim. They need a fitness to return to work certification from the physician. So it is typically required. Let's talk about the benefits while they're on the leave. So if someone is out on an ADA leave, you must provide the same benefits as those provided to those on a non-ADA leave. So that's important because if someone goes out on a medical leave of absence, what do you do with their benefits? Whatever you do with their benefits, you have to do with a person who is on an ADA leave. Under FMLA, health coverage has to be continued at the same level as before the leave, and other benefits would follow the established policy that you have for other leaves. Most of the time, you'll see that when someone goes out on FMLA, there are specific rules in that law for benefits. A person can decide they don't want the benefits during that time and reinstate them when they return. And not pay for them while they're gone, or they can pay for them before they go on leave, while they're on leave, or after they get back, depending on what the arrangement is with the employer. And then workers' comp, you'll have every attorney in the world tell you that you have to continue their health insurance while they're on a workers' comp leave. That's not the case. It is not required to be continued unless it runs concurrently with an FMLA leave, or um, what you want to do is follow the policy in place for other leaves. I will tell you, take a look at your insurance contract. Most contracts with insurance companies say that you can have someone out on a leave of absence for up to 90 days, which is 12 weeks, and complies with or follows the pattern that FMLA, a requirement that they've established. Workers' comp is the same way. Do not continue someone past that date that your insurance company requires, because if the insurance, let's just say you leave someone on the plan for 6 months, and while they're out there have a terrible car accident and they're filing claims for that car accident, the insurance company will want to know what their last day of work was. And if it's more than 90 days out from their first day of leave, you're probably going to end up paying the claims for that car crash. So make sure that you do whatever you do according to your contract and according to the policies that you have established for other medical leaves of absence. Don't let someone browbeat you into feeling like you have to consider workers' comp as a benefit that has a, I'm sorry, as a leave that has a higher benefit. It does not. No state laws require it. And let's talk about reinstatement. Under ADA, it requires reinstatement to their previous job unless doing so would create an undue hardship on the employer, and that is with an accommodation, a reasonable accommodation. Under FMLA, there is required reinstatement to the same or equivalent job, and there's no hardship exception. And then under workers' comp, there are no reinstatement rights under workers' comp in most states. Check with your insurance carrier or your state laws. If you can't find it, just give me a call, shoot me an email, and I'll find it for you. But generally, under most state laws, you do not have to reinstate them to their position. Now let's go into this example of the interaction of these leaves. Alice is the employee, and she's an assembly line worker who is full-time, has worked for the company for 3 years, and has perfect attendance. The company is ABC Manufacturing, and they have more than 500 employees. Alice calls in sick for 3 days, complaining of extreme back pain. She calls sick on the fourth day, stating she was examined by the doctor who took x-rays and told her she needs to have complete bed rest and possible surgery, and that she would be unable to work for an extended period of time. Alice does report that the physician believes that the condition is caused by the type of work she performs at ABC Manufacturing. So let's look at this situation. The employer coverage, ABC Manufacturing is covered under and must comply with all three of the laws, ADA, FMLA, and state workers' comp laws. And if she's in California, there are more laws to throw in there for paid family medical leave. The employee eligibility is that Alice may be protected under ADA depending on the severity of the condition. She is eligible for FMLA leave, and a claim must be filed because the doctor said it must have happened at work, and a determination made by your insurance carrier. So all of these leaves will apply and will run concurrently. That means one on top of the other at the same time. So you have to track each one of these and use all of the different laws and types of certification that are required. So the length of the leave, leave as a reasonable accommodation is not necessary at this point since she's covered under FMLA, so they're not requesting an ADA leave at this point in time. So right now we only have two laws to look at. If her absence exceeds the 12 weeks, then additional leave may be requested as a reasonable accommodation. We tell you with any person who's out on a medical leave of absence, if they can't come back because of that condition at the end of their leave, don't terminate them. Find out if there is a reasonable accommodation that you can make to get them back to work. And if that's not the case, a reasonable accommodation would be to extend their leave of absence. So never terminate someone who can't return from a medical leave unless you've analyzed the situation and determined if allowing a little bit more time would allow the person to return to work. So under FMLA, Alice is entitled to 12 weeks of leave because she meets the eligibility rules. And under workers' comp, if the condition is deemed work-related, her workers' compensation leave will run concurrently with her FMLA leave. Now, if the person is on an FMLA leave, there's a payment issue there. They will be getting workers' comp benefits, and if you have a short-term disability plan or some type of a paid sick leave program at work, that's another story. Those have to integrate with the workers' compensation pay. It may be that if you have some sort of a short-term disability or paid leave in place, that you would need to do that before workers' comp starts, and then the workers' comp carrier would take over. As far as medical documentation, there's none required at this time because she's still within that 12-week time frame, so she is not requesting any sort of accommodation. Under FMLA, you can require Alice to complete the FMLA medical certification. And if it's workers' comp, it's required by medical documentation will be required by the insurance company. Restricted or light duty under ADA. ADA is not required at this time since she's unable to work in any capacity. But if she could come back, light duty would be a reasonable accommodation when she's able to return to work. Under FMLA, you cannot require light duty while on FMLA leave. And under workers' comp, it should be offered to Alice. Maybe you could have her sit at the desk and answer phones if she's able to sit, or stand somewhere and put widgets together. Whatever would be approved by the physician. Speaking of that, the fitness to return to work certification you would need, even if it's a light duty job, you would need that. Under ADA, it's not required until she's not able to, until she's able to return to work. Under FMLA, Alice may be required to produce the certification if you request it. And under workers' comp, the insurance company is going to require it. The benefits while on leave, ADA, they're not required to continue benefits. Under FMLA, and that is if she's not working at all, However, on FMLA, her health benefits will be continued at the same level as before her leave, as long as she pays for it or makes arrangements to pay for it. And then other benefits are continued following the policy for all non-FMLA leaves. Under workers' comp, continuation of benefits is not a requirement under the law. And as far as reinstatement goes, Alice must be reinstated to her previous job unless it creates an undue hardship on the employer. And that is, if you could come up with a light duty job that does not place an undue hardship on the employer, then you would need to do that. Under FMLA, reinstatement is required and it has to be in the same position or an equivalent position. And under workers' comp, there is no requirement for Alice to be reinstated. So it looks like FMLA would reign here. She would need to be reinstated to her same or equivalent job if she's coming back to work full time. If not, and she requires an accommodation, then you could possibly avoid that by putting her in another position that where she can perform the job duties. So here's a summary of this. There are 3 laws that have different purposes. ADA prohibits against discrimination for those who have a disability or a disabling condition. FMLA establishes minimum leave standards and the rules under that leave. And workers' compensation laws provide for payment of wages and rehabilitation for workplace injuries, and it controls the employer's liability. Because it is a no-fault system, then it is considered they basically cannot be sued. When you see the attorneys on television that are saying call us, you're not calling to sue your employer. You're calling to deal with the insurance company and get the most benefit that you can, a settlement basically. Employers need to recognize the interplay of these 3 leaves, and on top of that, the state leaves that are now out there complicating things. Whenever medical leave occurs, more than one law may be involved, and probably is, I'd say, in most situations. So start your analysis with workers' comp. If that's not work-related, then consider FMLA next, or the state paid leave. Consider your legal responsibilities, and then consider the company's ethical and moral responsibilities, because it can get complicated. Okay, this is a time for questions. Let's go back to questions. Also, I wanted to point out that in the handout section of your screen, there is a handout of today's presentation. If you have a question, you can type it into the questions box. And it looks like we might just have one here. So let me just, okay, no, that was about the audio from the beginning, and I think we've started over there. So any other questions? You know, if you need more information on any of these types of leaves or on your state leave, please reach out to one of us. We can certainly help you with all of the information you ever wanted to know. We have lots of good resources and can provide those to you. That does come as part of your pay entry payroll subscription. So you can give us a call. We'll shoot you a copy of an article or a policy or a form, and would also love to help you as an HRservices client if you're interested in outsourcing part of your HR responsibilities. We'd love to help you. So give us a call anytime. We look forward to seeing you at next week's webinar, and hope you have a great afternoon.